Okay, it's 11 o'clock. Let's start it. Because as usual, people will start joining later on. Good morning, everyone. Welcome to the weekly Saturday knowledge sharing webinar organized by Mehta and Mehta. Thanks all of you for your continuous support to us. And today's topic on Masterclass on Companies Act 2013 is an insight into appointment of managerial personnel and remuneration. Very crucial topic because we are dealing with the top position under this section. Any mistake, misinterpretation will create havoc. And to present the same, we have today Ms. Khadija Indorwala, Associate Partner, Mehta and Mehta. Welcome, Khadija. Today, our panelist is Mr. Manikantha. Everyone knows him. Company Secretary, Infosys. Well-known personality under CS fraternity. To introduce Mr. Manikantha, his profile is long, but to make it short and sweet, Mr. Manikantha is a qualified company secretary, having 2 decades of experience. He has rich experience in various fields such as corporate governance, corporate secretarial, treasury, finance, compliance management, mergers and acquisitions, etc. He is currently working as a company secretary of Infosys Limited and oversees the secretarial function of the entire group. He is an active member of FICCI Corporate Law Committee, member of CII Research, member of CII, CII Regulatory Affairs Committee, member of Secretarial Standard Board of ICSI, member of Industry Standards Forum, constituted under SEBI and various other forums. He is a regular speaker at ICSI and various other forums. Welcome, Mr. Manikantha. Thanks a lot for your time.
Thank you, ma'am. Thank you for providing this an opportunity. And it is always a pleasure to be part of this knowledge enriching session. So thanks a lot for having me as a panelist.
Thanks a lot. As usual, friends, we have with us Mr. Bala and Mr. Sudhakar, stars of our organization. They need not need any introduction. So we'll go ahead with that. And just to introduce the little bit topic and the presentation style. Today we have changed little presentation as suggested by the panelists that we are taking decided cases first and then the provisions. So that gives us the understanding of the importance and how the wrong interpretation or wrong situation handling has an impact and why we should be very careful in interpreting these provisions. And I will now request all panelists for joining today's webinar and sharing their journey. And I'll request Mr. Manikantha to share a few words on the topic, then Mr. Sudhakar, and then Bala, and then Khadija, you can start the presentation. Over to Mr. Manikantha, please.
Thank you, Dipti. Once again, thanks for having me as a panelist. It's always a pleasure to be part of this session. And it's a great learning opportunity. So thanks a lot for that. Before I go ahead, I just want to put on record to say that whatever I speak today is all my personal points of view. It's nothing to do with my employer. It's not a view of my employer. That's on the record. So we were discussing on this topic of what should be presented for this session. Right? And I think we were discussing many topics, as you very well know. And then we browsed through some of the new case laws and cases which were playing in the media. And apparently we found that the managerial remuneration is one of the key aspect or one of the key issue, which was actually, there was a lot of public spat and there's a lot of news which is happening from the last 4 or 5 years. And if you see the proxy advisory firms and the voting pattern or the voting results of these kind of remuneration and appointment of the managerial personnel is one of the top, it is actually one of the top resolution which gets defeated. So therefore, we thought that it is very relevant for our professional friends to know the importance of this topic. And as you rightly said in your opening remarks, these are all high stakes. There is a very, very high stake involved. There is an interest of the larger shareholders, stakeholders, the company, the management, and the individual. It's an individual himself. So therefore, it's a very high stakes. And any misinterpretation, or if you take this matter lightly, it have a serious ramifications. I think during the presentation, you will also hear some of the case laws, which will give you a synopsis of how relevant and how important this area is, and therefore how care you have to take on this specific topic. So I think that's the reason why we chose this topic as a discussion point for this specific day. I would encourage all the attendees to ask questions and see in case if they have any doubts, please get clarified. Maybe we'll not be in a position to answer some of the nuances, but having said that, we'll try and address some of them. This is not a advisory or a opinion sharing platform, but we will provide whatever is best possible from our viewpoint, the interpretations of what we think is right. So thanks, Dipti, once again, and over to you.
Thank you. Thank you. Sudhakar, please.
Yeah. Hi, good morning, everyone. In fact, when I'm looking for the managerial remuneration, I always remember, and I told several times, that the procedural rigmaroles used to be there more earlier, whereas now legal rigmaroles are more. When I qualified in 1985, in those days, to determine the strength of a company secretary, one of the things is whether you will be able to get the managerial remuneration approved. Because it was mandatory that the central government has to approve the managerial remuneration. I remember the first company where I joined, it was a joint venture company with a Japanese company. And the managing director was an expat, and we were to get his remuneration approved. You can't believe that the managerial remuneration, what we were to pay at that point of time, was 3,500 rupees per month, all inclusive. That was the managerial remuneration which we were to pay to that expat. And we went to Shastri Bhavan. We have been called for an interview. And that Japanese person, we took him along with an interpreter also. And ultimately, after 1 hour of discussion and all, the remuneration approved was 2,800 rupees. Can you believe that? From there, we have started our journey. And today, after almost about 40 years, there is no central government approval is required except for one, that is Schedule 5, Part 1 of Section 1, I think it is. In case of any kind
how
of
much
defaults.
time, Sudhakar, to get the approval?
That, in fact, almost it took us 9 months.
Yeah, that is it.
See, time period, let us leave it aside, but what I'm trying to say is 3,500 rupees we proposed and 2,800 rupees was approved.
No, not only that,
the ability of the company secretary, in those days, how good you have the liaison with the ministry was the determining factor. Now, coming back to the present regulations are concerned, several people think that the managerial remuneration guidelines are not applicable to private limited companies, which is not correct. Section 197 is not exempt for the private limited companies. Only thing is Section 197, subsection 1, 2, and 12 are applicable to public companies, and all the remaining sections are applicable to the companies. The company means it is a private company. So private companies, till the time they have profits, they can pay whatever the remuneration they want to pay because the percentages are not applicable to them. And no special resolutions as such are required. As far as other procedural formalities are concerned, that means in case of inadequacy of profits in case of private companies, according to me, they have to comply with the remaining provisions of Section 197. And of course, in case of listed companies, apart from the legal rigmaroles, you also have the procedural formality, that is the approval of shareholders. That means the greedy people who are having high level of managerial remunerations, and especially proxy advisories, they are taking care of the section 197, subsection 12, where you have to give the median remuneration also. That is quite visible that if you see the kind of disparity what is there, a few companies where the shareholders have rejected that approval. Finally, before giving a pause, I would like to say that related party transactions are also there, which we will discuss while that we are going through the presentation. Because some people think that's because it is whether it is a related party transaction or not, Section 188 approval is required or not. All those things we will discuss it at the time of at an opportune time while the presentation is in progress. I give a pause and request Bala to take over. Thank you.
Good morning to all of you. I have a great pleasure in welcoming you all. And it is always a pleasure to hear from the people who are expert in the field, especially people like Manikandan and Sudhakar. As Sudhakar said it, 3,500 rupees was struggling to get approval for almost about 9 months. The same case here, I was struggling to get approval of 5,000 rupees. It took almost about 14 months for me. That is why I asked for the time initially. So those are the days where we are struggling so much bureaucratical issue, procedural issue, information, assimilating the information, all those things we have gone through. But luckily today, what has happened is government has realized they don't want to interfere in the business community. It is their business to run the business so long as they are able to comply with the requirements. They are run ethically. They are doing the right thing. They don't want to interfere. That seems to be a mindset of the regulator. So with the result, what has happened is nowadays there is almost government approvals have been actually done away with it because they have realized it is a shareholders democracy. And even India, in the recent past, if you have seen, the shareholder activism is actually picking up. And as Manikandan puts it very clearly, it is actually proxy advisory firms who are playing the excellent role. Many of you have been seeing the news media, news listening from you also. The current issue, which is highly going on and delicate and managerial remuneration issue only, where the shareholders actually rejected. Sometime back, in the case of the Lupin, they wanted to propose some 6 million ESOP scheme for the employees, managerial employees related, which was actually defeated. Almost about 79% of the institutional shareholders voting. Such cases were also there in the past, if you may be aware. Not only one or two cases, there are a lot of cases. It has happened with the Hero Motor, it has happened with the Titan, JB Chemical, many issues are there. So it itself shows what is the importance of the topic, how the people are looking about the compliant company, good governed company, how the shareholders are exercising their option. All the things are all there. As Sudhakar puts it, law may forbid something, but are we doing the right thing is the next. Because many of the presentation, he always used to say, it is governance is not only doing the things correctly, but it is also for the right thing, right purpose, for the right cause. That is what he always used to address. I heard him also. So with that, the importance of the managerial remuneration approach so much important. There are a lot of things that has to get into the mind. We professional, especially the company secretary or the compliance officer, we have to advise what is right, what is wrong, what is to be done, etc. These are all very important. So I think today's topic will be able to hear the benefit of Mr. Manikandan and as well as Sudhakar on this expert field. One thing, as Manikandan cautioned earlier, please do not raise any specific particular question which is pertaining to your organization, because without doing much of the fact, we will not be able to answer any particular things. But at the same time, we welcome you any question related to procedural issues, general nature, interpretational issue, etc. and other things and all. You can put on your chat box. We will take up in the appropriate time. And at the end of the session, you are permitted to raise your hands. We can allow you to speak. We can answer it. I think I look forward to the great learning with the two stalwarts who are actually with this today's session. With this, I request to start the presentation. Over to Khadija, please.
Thank you.
Okay. Good morning, everyone. So thank you, Diptiman, for giving the opportunity to present with such a vital topic today. So we'll start the screen.
The screen is visible.
Yeah, but first slide is not the.
Yeah.
Yeah.
Okay. So today's topic is, as discussed by Dipti ma'am, an insight into appointment of managerial personnel and remuneration. So as Manikantan sir have already discussed that today we are changing it by starting first with the case laws. Okay. So the first case law, that is Sridhar Sundaranjan versus Ultramarine and Pigments Limited. Now I will present the fact of the case. The facts are that there are defendant company was a public listed company, and the defendant, second defendant, was appointed as a chairman and managing director of the first defendant company in the year 1990. On 1998, the plaintiff was appointed as a director of the first defendant, and in 2012, the second defendant was reappointed chairman and managing director of the first defendant company for a further 5 years till 2017. On that date, the plaintiff was also appointed as a joint managing director of the first defendant company. And in 2014, the Companies Act 2013 got into force, and it introduced an upper age and lower age limit, that is of 21 years and 70 years respectively. So this case majorly deals on the age limit criteria, which is there in section. Now, the plaintiff sought an order against the second defendant from functioning or continuing to exercise his power as chairman and managing director of the first defendant company. It was the plaintiff case that since the second defendant attained the age of 70 years in 2014, his 5 year term as managing director, one that commenced on 2012, came to an end by operation of law in 2014. Now, in this case, it was held that individual below the age of 21 cannot be appointed as managing director, full-time director, or manager of a public limited company, and there are no exceptions to this rule. If for those who turn 70-year-old, the statute introduced a proviso that indicates that if a person is appointed over and above the age of 70 years, a special resolution needs to be passed by calling a EOGM in the general meeting. Now, the proviso to section 196(3)(a) requires a special resolution for the appointment of individual over 70, differing from other disqualifying conditions, insolvency or criminal conviction that mandate immediately cessation without acceptation. This section is of Companies Act 1956. Various scenarios illustrate that section 196(3) does not mandate stopping a tenure due to reaching the age of 70 midterm. Such an interpretation will lead to unreasonable outcome that lack legislative intent. Now, Section 269 of 1956 required a special resolution for appointment of individual over 70 years, but did not enforce automatic midterm cessation. So in 2013, the continues this principle. 1996(3) of the Companies Act 2013 Act should be understood to require special resolution for appointment or reappointment involving individual over 70. Existing appointment, the court found that the plaintiff request for interim relief presently seeking to enforce a cessation based on age will not be granted. Over to the panelists.
Any comment, panelist?
No, I don't have
nothing.
anything specific as such up to here.
No, nothing. It is actually self-explanatory. What is important is the interpretation of the correct procedure. That is what is involved. The application of the mind is involved. There is nothing. Yeah. Otherwise, the case itself is self-explanatory. Yeah. Go ahead.
Yeah. Now, this is the next case. Eicher Motor case, where Siddhartha Lal was appointed for reappointment as managing director of Eicher Motors in 2021. The proposal included a 10% salary hike during the pandemic, despite decreased company revenues. So institutional shareholder rejected both the reappointment and the salary
The
hike with
only
significant.
condition say, I suggest that why can't we talk the provisions first and then the case laws? Why we are starting with the case laws?
No, so I think
Why not to start with the provisions first,
No, no.
After that, it is better to go ahead with the case laws.
Yeah, Mr. Manikantha.
no. So we were discussing yesterday of what should be the format, and just to reinforce the importance and just to showcase uh, how important it is and how much stakes are involved in each case. We wanted to just give an overview of some of the recent cases which have happened.
I do appreciate money. I do appreciate that. But sometimes what happens is some of the participants who might be the budding company secretaries. So if they have to get connected to the case law, that fundamental provisions are very important.
Yeah,
What is the law says first instead of the what the case law is decided. Unless until I know what is the law, I may not be able to appreciate the case law. That's what my view is. Anyway, go ahead. If you have already discussed the pattern, go
No,
ahead with
no,
that.
because the whole idea is that, we wanted to talk about the impact so that, it shows what is the important way we are talking. Otherwise, people will think the manager will know what is there. There's a rule, regulation, laid out things there, we can go, which is not the case here. Because the impact is involved is so much, so we wanted to bring out the impact first. That was the case. Yesterday, myself and Mani, we were discussing actually. In fact, yesterday while preparing the presentation, case laws were put at the last. So then we thought, it is better that we talk about the impact so that the importance of the topic is actually known, so that this will be better, because everybody will be definitely knowing the law, regulations, etc., because they are all qualified company secretaries. Many of them are actually in the employment and the practice. That is why we thought of starting with the impact. Yeah.
Anyway, that Bala, you may go ahead, but definitely, though people might be thinking that they know the law very well,
Yeah.
but there are several company secretaries that doesn't know the difference between the manager and the managing director with all due regards. Even the senior company secretaries also, people have a wrong notion that the managing director is superior to a manager. So those kind of niceties we have to bring out. As
Fine.
we all know very well that the manager position is superior to that of a managing director. A company can have more than two managing directors or five managing directors also, but a company cannot have more than one manager. What is the reason for that? Anyway, these are the points we will discuss it, no doubt about it. I don't want to disturb the pattern which has already been decided upon. So kindly go ahead with that.
We will run through fast these decided cases and then we will take. Yeah. Khadija, you run through fast so that we have more discussion. Okay.
Okay, ma'am. Okay.
Go to the
So
provisions and then we can come back. That is also we fine, right? If you want to touch upon the provisions first, let's do that. We can come back to this afterwards.
Okay. What do you suggest, panelists? Shall we take provisions first?
Yeah, I think if that is the protocol, let's go ahead. No, there's no problem. Let's go ahead with that.
Okay, Khadija, move to the slides only.
okay,
Provisions, sorry, I mean to say.
okay.
Yeah.
So let's discuss with the definitions of KMP. What is KMP and what is written in that? So key managerial person in relation to a company means the chief executive officer or the managing director or manager of the company secretary, the whole-time director, and the CFO. Further, we have bifurcated the term and discussed by Sir. The managing director, people doesn't know the definition properly of managing director and manager. So here it is. Manager means an individual who subject to the superintendence or control and direction of the board of directors has the management of the whole or substantially of the whole of the affairs of a company and includes the director or any other occupying the position of a manager by whatever name called when under a contract of a service or not. Now, managing director means a director who, by virtue of the articles of a company or an agreement with the company or a resolution passed in its general meeting or by its board of director, is entrusted with substantial power of management of the affairs of the company and includes the director occupying the position of managing director by whatever name called. Now, The power to do administrative of a routine nature when so authorized by the board, such as the power to affix the common seal of the company to any document or to draw or endorse any check on the account of the company in any bank or to draw and endorse any negotiable instrument is direct registration or transfer of any share is deemed to be included with substantial power of the management itself. Um, Panelists would like to tell anything on that.
Yeah, go ahead further and go ahead further.
Yeah.
We will intervene.
Okay.
Yeah.
So now further we have what is officer in default. So officer in default refers to individual in a company who can be held liable for penalties or punishment. That includes both fine as well as imprisonment of any violation or default in the law. Now this include individuals that is whole-time director, the key managerial personnel as discussed, director specified by the board when no KMPR is appointed, or all the director if there is no specified director specified, person charged by the board or key managerial personnel with specific responsibility, either knowingly allow any default. Person who advise or instruction the board of directors habitually follows except those advising in a professional capacity. Any director who is aware of the contravention and either participates without objections or give consent for the violation. Now, in matter of share issuance or transfer, share transfer register, registrar, and merchant bankers. So, by this, the definition is concluded.
Yeah, we want to go back to the previous slide. I just want to show the importance and the veracity of how it can be wrote and how the responsibilities can be fixed on various people in case if there is a default. Just one slide back, please.
Yeah.
Yeah. So if you see this officer who is in default, the way it has been described or the entries which you see from 1 to 4 and the following, right? So they are trying to fix the responsibility on all these individuals. Now, full-time directors, the managing director is only one part of it. And in case if you have many executive directors, so they will also come into the ambit. And KMP, in case of a Companies Act, the company secretary, the CFO, and the executive directors, everybody will come into play under Section 203. Right? And the directors who are specified in the board will also come into the play. I just wanted to showcase the veracity and the depth of these people of how much scope the ROC will have to charge against in case if the wrong things go, and who are all the persons. And I think all of you know when if there is an officer who is in default, which means that they will also be personally liable. It is not only the company is defending, the company and the individuals will also get penalized or get accused in the matter. And therefore, it is their responsibility to come out and say why they believe or why they have acted in good faith and they have acted in accordance with the law. I think that's the whole requirement and whole importance of why there is a definition of officer rules.
Just go back to the previous slide. Previous slide where you have the definition of manager and managing director. Yeah. See here, I would like to bring this distinction between the manager and managing director. Normally, we all have a wrong impression that even several people have this thing that manager means as if it is a middle level position. In fact, under the Companies Act, if a person has been appointed as a manager by the board, it is a position superior to that of a managing director. Managing director may have been or may not have been given the full powers or substantial powers of the company. And second thing is managing director is not deriving the powers from the act as such. managing director is to be delegated the powers, either by the articles or by the resolution in which he has been appointed, or by way of an agreement. Whereas in case of a manager, he is deriving the powers from the act itself. He has the power to manage the whole or substantially whole of the affairs of the company. And that is the reason actually you cannot have under section 196, you cannot have a manager as well as a managing director at the same time. You can have a manager or a managing director. You cannot have both the positions simultaneously. Number two, a company can have more than one managing director. In fact, you might have seen there are some companies like State Bank of India and all. Of course, State Bank of India is not a company under the Companies Act, but there are certain public sector undertakings where they have more than one managing director. Joint managing directors, they may be called as, because that managing directors have been delegated a portion of the powers of the company, not the wholly or substantially whole of the affairs of the company. Similarly, along with the managing director, a whole-time director can also be there. At the same point of time, along with the manager, a whole-time director can be there. But along with the manager, a managing director cannot be there. So there is a distinction between these two, number one. Number two, manager position, as I have mentioned to you, under the Act, it is not a junior position, it is a superior position. Okay.
I remember
Mani, if
that.
you would like to comment anything about this, or Bala.
The only thing is, I remember, in 1956 Act, when we used to be there, generally the company used to be, smaller companies, used to be managed by the non-full-time directors. And then what they used to do is they used to appoint a person, whatever you said here, either he is a manager or the chief executive officer or chief works executive or something like that, and other thing, and that would be entrusted the total power. And once the company goes with the board of directors, then in such a cases, it is their choice either to have the managing director or the manager, but by and large, they used to have the managing director when the full-time directors appointed the company. That is what I have actually seen in the earlier days. Because initially, when we were an unlisted public company, we were actually having a manager only who was the expatriate, where I was to get the approval even for him because the expatriate person was getting a salary. But subsequently, the company went to full-fledged, it went into public, and then it was a fully constituted board of directors, management, etc. Then we changed to the managing director.
Yeah, no, I just wanted to add 2 points. One is the managing director. If you read it, it is an agreement. There is an agreement with the managing director. So the agreement has to be prima facie approved by the shareholders. That's point number one. All the terms of appointment, the scope of what he works and what he will be responsible for will be highlighted or will be detailed out in this managing director. And that's why Sudhakar was also giving an example of a company can actually have multiple managing directors. In fact, another company which I can think is LIC. LIC now it is earlier it was not a Companies Act, right? But though it is not a Companies Act now, they have gone to the listed company. They have a listed company, therefore they are bound by the requirements of the listing regulations. That is one company where you see that there are a lot of managing directors who have been appointed for various purposes. And the significance of having these agreements with the managing director is also that it is their bond for whatever has been prescribed with that. And the agreement has to be approved by the shareholders, which means that if you don't have an approval from the shareholder, then the agreement with the managing director is null and void. So I just wanted to give you that flavor of where the company can have multiple managing directors as well.
In fact, Mani, I can give an example of Reliance Industries when Mr. Dhirubhai Ambani was alive. That time, Dhirubhai used to be the chairman and managing director, and Mukesh Ambani and Anil Ambani used to be the joint managing directors. So there were three managing directors at that point of time. They have different responsibilities along with that. And another feature of manager and managing director is the manager need not be on the board. He cannot be rather.
Yes.
Manager is not a director of the company, so he is not there on the board. And apart from that thing, another very interesting feature is whether the manager, by way of a service, by way of a contract or not, even if there is no service contract, but if he is having whole of the substantial powers of the company, the deeming provision is there, he can be deemed to be a manager. That sort of deeming provision is not there for a managing director. That means technically under the Companies Act, though there is no service contract between the company and the manager concerned,
Yeah.
but if he is exercising the substantial powers of the company, he can be deemed to be a manager of the company. The deeming provision is there both under the old act as well as under the new act also. Yeah.
Yeah, yes, go ahead.
Okay. So now it is KMP is applicable to which all company? This is covered in this diagram. So whole time KMP is applicable to a listed and unlisted public companies. And for private company, CS is applicable. Full time company secretary is applicable. Whose paid up share capital in the exceeds 10 crore or more. Now, section 196 talks about appointment of managing director, whole-time director, or manager. As discussed by the panelists, that simultaneously a company cannot have a managing director or manager at the same time. Then the reappointment or appointment of a managing director, whole-time director, or manager cannot exceed 5 years, and reappointment cannot occur earlier than 1 year before the expiry of the term. Then we talk about the age limit. As discussed in earlier case law also, that it is self-explanatory that a person who is getting appointed as a managing director, manager, or whole-time director cannot be below the age of 21 years and cannot be above the age of 70 years. If it so happens, then a special resolution needs to be taken in the general meeting. And a justification related to his appointment or her appointment needs to be uh, shown in the explanatory statement. Now, if the such a resolution fails but receive more favorable vote, the central government can approve the appointment if deemed beneficial. And also, if an individual cannot be appointed, the disqualification is mentioned here that a whole-time director, a manager, or a managing director cannot be appointed if he is insolvent, have suspended payment to the creditors, or made arrangement with them, or have been convicted with a crime with a sentence exceeding 6 months. Now, moving to next slide, where we have covered the filing which needs to be done to the ROC. There are 3 forms which need to be filed to the ROC. That is the MR1, which needs to be filed within 60 days of his appointment, Form DI-12, and Form MGT-14. Now, these 3 forms needs to be filed in the case of a listed company and unlisted public company, whereas it comes to a private company, the Form MGT-14 filings gets exempted. So in case of private, we have to file only DI-12 and MR1.
Yeah, if you can go to the previous slide, I just wanted to highlight one point.
Okay, sir.
See, I think the second bullet which you see, this appointment or reappointment, especially the reappointment, it cannot be done before it cannot be done before the expiry of 1 year. Meaning, if it is a 5-year term, if you want to renew or reappoint, it cannot occur earlier than 1 year before the end of the expiry of the term. Why is it done? There's a lot of cases. In fact, there are few cases where the existing contract of a managing director will get terminated by agreement with both the parties, and the fresh agreement or the fresh tenure will get renewed once again. So this is a creative way of few of the companies have adopted. Though they try to negotiate the salary or the revise the terms and package. Therefore, whatever they had agreed for in the first instance, where you would have agreed for a period of 5 years, at the end of 1 year or 2 year, you may find that it is not fitting for both the parties. So therefore, what they try to do is smartly, they try to terminate the existing contract, enter into a new contract just to come out of this specific provision to say that you cannot reappoint earlier than 1 year before the terms expire. I thought I just wanted to highlight that development which is happening in few companies.
Right, this was there under the old act. You could have appointed before 2 years. It
Correct.
has been now reduced to 1 year. In the old act, you could have appointed a person reappointment before 2 years also, which is now reduced. And one more thing also is that some people have a wrong notion that this 5 years term means that the managing director 5 year is he need not retire by rotation. That is not correct. Managing directors or whole-time directors who have been appointed for a term of 5 years, it all depends upon how you are passing the resolution. If you are passing the resolution that he need not liable to retire by rotation, then only his position is there for 5 years. Otherwise, managing directors or whole-time directors, they have to retire by rotation. So you have to see the section 152, that 2/3 of the directors of the board size have to retire by rotation, out of which 1/3 have to retire by rotation every year. That the composition of the board, you need to take care of that. So that point of time, managing director, whole-time directors may also retire by rotation. Then the question comes, suppose when he is retiring by rotation, suppose he has not been appointed as a director, though he has been appointed as a director for a term of 5 years earlier. But when his position is coming for retirement by rotation and he has not been approved as a director, what will happen to his managing directorship? Because he is no more a director, obviously that managing director position is also not going to be there. Since he has not been appointed, because to become a managing director, a person has to be a director first, then only he can be a managing director. Now, when you are reappointing that, the managing director who is retiring by rotation, when you are appointing him, you are appointing him only as a director, not as a managing director. So his terms and conditions of his appointment will be intact. Whatever the earlier resolution was there, it will go as per that only. There will not be any change. Only thing what is going to happen is his position is coming to retire by rotation. And if he approved it, he will continue as a managing director as per the earlier terms and conditions approved. Yeah.
I think it's a very brilliant point which you made, Parker. I think you rightly put it across. So there are two positions which are involved in a managing director. One is a basic position is a director, and then there is a managing director. So therefore, the rotation has to happen as per the section 152, where you have to rotate 1/3 of your board mandatorily every year, right? And also, what happens if I take that argument further, where you mentioned you gave a scenario of earlier, let's say if he doesn't get reappointed as a director, then the whole thing falls. Therefore, he cannot hold the position of the managing director. But if you extend that argument, let's say he's completed the managing director, but he's still there as a director, he can still continue as a director. He can still continue as a director, but relinquishing the position of a managing director. But he may he may become a non-executive director as he go forward. Right? I think that's the nuance which you need to look at it.
So that
I fully agree with your money on that. Suppose if a person has been appointed and his term as a managing director terminates, but he can continue as a director for the remaining position. This thing, I fully agree with you.
In fact,
only thing is
companies. In fact, there are few companies.
New thing, what I try to brought here is Sorry, go ahead. Go ahead.
No, I was just saying there are few companies where they are overlooking this, which
Okay.
means that, let's say, if the managing director term is ending, and if he has been appointed, if he has been reappointed in the previous AGM, then his term as a director is still continuing. So that is still not vacated. So I think many of them think that, okay, because the managing director term is ended, therefore his directorship has also been vacated. But that's not the case. So you need to comply with both the requirements of a director and managing director.
Yeah, and
So
that is
for the sorry, Dipti, go ahead.
generally question asked, people forget to take this, appointment and as such, MD appointment. And then what they try to say that if it can be retrospective effect. That is generally the question. He is a director.
Just to, just to give the example of what money has brought, the final point here is, said normally what happened is a director position comes for retiring by rotation once in 3 years. Okay, so for example, if you have appointed a person as a director and as a managing director for a period of 5 years, and he's liable to retire by rotation, when he has been reappointed after when he is retired by rotation, it is going to be for next 3 years. That means 6 years he is going to be there.
Correct.
Suppose in the next term, second year, his 5-year managing directorship is over and he has not been reappointed as a managing director. The fine point what Mani is trying to bring here is he need not vacate his position as a director. He can continue as a non-executive director for the remaining 1 year.
Correct.
Though he is not going to be the managing director. This is one scenario. The second scenario, what I have given was, suppose, for example, in after 3 years, when his position is coming to retire by rotation, the point of time his approval, his position as a director is not approved by the shareholders. Then what happened is, since he is not a director, he cannot be a managing director also. Though his appointment was there for a period of 5 years, since his director position has not been approved, he cannot act as a managing director thereafter. Because for a person to act as a managing director, the prerequisite is he is to be a director on the board of the company. So these are the two important points which the participants may kindly take note of.
Same way, if it is appointed, he is appointed as an additional director and not regularized at AGM. Similar situation. Either retirement by rotation or he appointed as additional director. Forming same scenario. My also question was many times, people ask that if MD can be appointed with retrospective effect. What is your comment, panelist?
No, so the appointment, I divide this into two. Sorry, Sudhakar, I think you were about to say
Or
something.
reappointment. This renewal is not done or something. Reappointment. Can it be retrospective?
No, so you cannot, first for the reappointment, you cannot do a retrospective effect. Now, how will you do a retrospective effect? Because if, let's say, it's a future, if you have entered into a contract for a 5 year, you very well know that the 5 year term is ending on a particular date. Right? And then you cannot go after the completion of time period, you cannot go and sit in some other day and say that, okay, I am doing it retroactively. And for a simple reason of that, how is the obligation getting casted on some person, on a person who is occupying that occupying that position? Because the whole point of KMP and managing director, right, is there is a responsibility under section 203 also, where you are filing the DIR 12. And as we saw in another slide also, there is an officer in default provision as well. So therefore, considering all this, there is a requirement to do the appointment prospectively or on the date of appointment itself. You cannot do retrospectively at all. That's my view.
Yeah, what happens basically that people skip this, forget that timeline. And AGM date is not there, and that time. And the person continues to take that position because MD is not knowing for all this process. In this scenario, many come with these questions that whether I can do now in AGM, though it was 2 months back, I should have renewed the contract and ticket. So whether I can do this or not.
So there are 2 points. There are 2 points. One is appointment by the board itself, whether the board has an authority to appoint, reappoint or not. And second, whether the shareholders can do it or not. Right. I think the point which you are mentioning is whether the board has the capability to reappoint, though the AGM is at a later date. Now, I think for the reappointment of a managing director, I think it can be done. There is no prohibition. The prohibition is only for an independent director. For an independent director, you have to have a prior approval by the shareholders for the listed entities, right? But for the managing director, the board has a ability that you can reappoint him, and you have to get it regularized within a period of 3 months.
Okay. But whether it can be retrospective, same board meeting.
Cannot be. You cannot. I mean, that's my view that you cannot appoint anybody with a retrospective.
Because this is a practical questions many times, many CSRs. Okay.
See, Dipti, according to me, retrospective appointments are not correct. Okay, because board is not having a power for ratifying the contracts. I mean, this kind of contract, what I'm talking about is. But there is a divided opinion. Some uh, people say that a managing director can be appointed with a retrospective effect and all. But maybe sometimes, what happened with the reappointment with retrospective, still one can understand. But the first original appointment with the retrospective date, because at one point of time, somebody asked me that an additional director has been appointed. Now, down the line, after 3 months, they want to appoint him as a managing director with a retrospective date, that is from the date of his appointment as an additional director, because they want to pay him that 3 months salary because he was working as a managing director only, as if he's a managing director. So my answer to that was, you cannot appoint with the retrospective effect as such, because how can you do that? When he was appointed as an additional director, that time the mindset of the board is to appoint him as an additional director only. Had it been the what's called as the perception of the board to appoint him as a managing director, they would have done at that point of time only. And down the line, after 3 months, you want to appoint him with a retrospective date. That is not correct. But as such, the law is silent about this, because retrospective appointments can take place or not. The way it is there in 149 subsection 10 for reappointment of an independent director, it is clearly there. There also people still having a different interpretation. Though Mani and myself, we both are an SSB, we have the same view. But still some people say that independent director, second term and first term, there can be a break. All those things are there. Let us not get into that. But that kind of clarity is not there for the reappointment of a managing director. Suppose, say, for example, as you are mentioning, somebody has forgotten. After 2 months, he woke up and he says, maybe retrospective, we will do that and all. That clarity is not there. But since the law is silent about it, one can take a chance about it. But better always to appoint as a good governed company, as a good company secretary, you can reappoint the managing director before 1 year of his term expires. Because that 1 year window has been given by the law, it means what is expected from you is that in case the managing director's term is getting expired between 2 AGMs, it is always expected that you reappoint him at this previous AGM before his term expires. That's how we have to interpret the law.
Yeah. Mr. Bala, concern question, I will just connect it, then you take it. Khadija, the question is, MR1 is to be filed in case of MD appointment within 60 days of appointment. Appointment date is when the board resolution passed or when the shareholder resolution. 60 days to be counted from which date? Board resolution or members resolution? Panelist or Khadija, what?
I think it's from the board resolution.
It's from.
Sorry, Kadeja, you have done the research. Do you know?
Yes, it's from shareholders resolution, not board.
Okay.
Sudhakar and Mani.
So, sorry, before I come to you, Mr. Bala. Just reflecting on the previous point, Sudhakar, in my view, you cannot make a retrospective, though the law, I mean, I don't know how people are saying that the law is not clear. But because of the reasons which I mentioned, right? Because of the officer in default, there should be somebody who is taking care or taking charge. Who is that person in the intervening period? And you cannot say that, okay, for the acts which has happened, okay, so if nothing happens, nobody, they will say that, okay, I have been assuming my responsibilities on that day. But let's say for any God forbidden thing, something happens, who is taking charge on that day? So you cannot fix a responsibility under the officer in default if you have not appointed him from a prospective
Oh,
date.
see that money for that, they suppose I agree with you. I am a person who is against that retrospective appointments thing, right? I always go for before his term expires, I have to appoint him because the law provides 1 year before you can appoint the managing director. Means even law is also expecting you to do so. Now,
Right.
your question of officer in default is concerned, the company may have a whole-time director. The company may have a joint managing director. Not only a managing director simpliciter, quite possible it is. If that case, what will happen? They will be held responsible. So officer in default might not be a logic for going against this, I mean, with retrospective thing and all that. That's what my view is. I mean, people may argue like that.
Yeah,
So
there is
in
an
officer in
argument.
default, sorry, just to come back on that. So the officer in default, let's say even if there are full-time directors, the officer in default provision is on every full-time director and managing director and company secretary and
I
team,
agree.
right?
Correct.
So in that case, you cannot say that, okay, I am putting somebody on a retrospective effect and therefore he is not responsible for the acts which has happened on that day.
Yeah.
So
Yeah,
that's the point which I was trying to make.
yeah, there is an argument that why the shareholder resolution 5 years and appointment starts from board meeting date. So now the question is 5 years counting starts from which date?
From the board approval date.
From the board date,
There's a board approval. Yeah, yeah.
board
That is,
approval
there
date.
is no.
In fact, there is a proxy advisory firm who has given an against in a very recent case where where one company went and said that they are counting the date from the shareholders approval plus 5 years. So they came back and said that they have given a negative recommendation. It got turned down.
So then in that case, there is a argument from the participant that it should be from board meeting date because 5 years date of appointment becomes your board meeting date. So 60 days from
It's
now.
actually the other way around. The board meeting, whenever you are appointing him, is the date of appointment. See, in the board meeting, you can give a futuristic date also.
Yeah. Okay.
Mani and Sudhakar, all this discussion, one final point which is actually coming out. Whether the managing director is retired by rotation or not retired by rotation. Many of the people think they are not retired by rotation, which our clarification very categorically said they are also retired by rotation. That is number one. Number two, if you want them not to be retired by rotation, specifically your article should say so. That these are the set of the people who are not retired by rotation. That is another point. Again, coming back, if you remember, Sudhakar, our very first session on this, we started about the drafting of the documents, article, memorandum, etc. and all this thing. It goes back to, again, re-emphasize what is the importance of the drafting, what are the things we have to take care of it. In fact, in the company when I was working, we also have the managing director, whole-time director. But in our article, what it is, for the purpose of 1/3, by any chance, upon a given particular time, the 1/3 falls below for the retired by rotation, then the managing director and the whole-time director are also liable for return by direction in that particular situation. That was actually there. In one of the situations, it so happened that I was to make managing director the whole-time director by retired by rotation, discussed with the chairman, and accordingly adopted, even notices were sent out. Immediately after the notices were out, my managing director and whole-time director both called me, taken me for a task. How can you make us to retire? You mean to say if the shareholders start electing us, we lose the job? to such an extent, the argument has gone. I was actually young enough that time, really speaking. But this was the issue which I actually faced. Ultimately, I had to actually take them to one of the very senior company secretary at that particular time to tell them what I had done is right. That was the support I had actually taken. So again, I come back. What is the importance of drafting the documents at the time of incorporation itself with reference to article of association, taking care of the thing that goes very much important, where our professional has to play very, vigilant role on this. That is what I would like to advocate.
Okay.
I just want to give another scenario, which is a developing scenario in the new age of startups, where all these MNCs, when they come and constitute the board, right? The constitution of the board is completely with independent directors, and it is only one executive or the managing director who is a whole-time director, right? By virtue of the law, all the independent directors are not retired by rotation. They're all fixed term. Then if you say your articles also says, if the managing director is for a fixed term of 5 years and therefore is not liable to retire by rotation, then how are you complying with the requirements of 1/3 rotation? Right? I think that's where Sudhakar mentioned earlier that you need to take care of the proper composition of the board.
Yeah, that's right.
Right? And therefore you need to make the retirement of rotation every year. So in these scenarios, probably the managing director is going for a liable to retire by rotation every year to the shareholders.
Yeah. Okay.
See,
Yeah.
not only that, with all due regard, sometimes it happens. People for appointment of managing directors and the remuneration. What some company secretaries do is they pick up some resolution from somewhere, cut it and paste it with modification. Sometimes it so happens the intention of the management is that the managing director is not liable to retire by rotation. And the resolution what they have picked up is that the managing director is liable to retire by rotation. And here unconsciously he has got the resolution passed with the same thing filed with the ROC also. And subsequently, what happened was the managing director has not retired by rotation because that was not the intention at all. And the ROC catch hold of them at the time of inspection. That's why, in fact, when we started this with Section 2, that point of time itself, I said that the company secretaries, whenever you are changing a company or whenever you are accepting a new client, the first and foremost thing what you have to do is please go through the articles thoroughly, because articles are very, very important. At the same point of time, whenever we are passing a resolution, though we are taking the help of some other resolutions passed by some eminent companies, but you have to say, first of all, what you are exactly going to pass. You have to have your terms of appointment. Then you see the language.
Yeah, Khadija, go ahead.
Okay.
Yeah.
Okay. So, Section 197, which talks about overall maximum managerial remuneration and managerial remuneration.
1 minute, Khadija. Yeah, Mr.
Yeah.
No, I think the slides did not change. I'm okay. Please go.
Yeah. Section 197, which talks about overall managerial remuneration and remuneration in case of adequacy or no profits. So, in case 197 talks about 11%, there are certain caps which are mentioned in the section. That is 11% cap, 3% cap, 5% cap. So first I will talk about 11%. The total managerial remuneration payable by a public company to the whole-time director, managing director, or manager in any financial year shall not exceed 11% of the net profit for that financial year. And now, when we talk about net profit, the net profit needs to be calculated as per Section 198, which will be there in the next slide. How the calculation, what needs to be deducted, what not to be not to be taken in 198. Now, further moving ahead. Now, total managerial remuneration, if it exceeds 11%, then the shareholders' approval is required. Plus, payment should be subject to Schedule 5. Now, our Schedule 5 is divided in 4 parts. So as per the remuneration part, as per Schedule 5 remuneration part, it needs to be taken care in shareholders approval. Now, prior approval of banks, public financial institution, NCD holders or secured holders applicable in case of defaulting company needs to be taken. Now, if the remuneration to managerial personnel, in case if there is only one managing director, one whole-time director or manager should not exceed 5% of the net profit of the company. And if there are more than one such directors, the remuneration should not exceed 10% of the net profit of all such directors taken together. So here we talks about all in case of we have a managing director, full-time director or manager more than one. Where 5% talks about where there is only one managing director, full-time director or manager. Now, in case where the remuneration to director other than managerial person, that is MEDs, so it talks about 1% of the net profit of the company if there is a managing director, full-time director, and manager, and 3% of the net profit in any other case. So this is the bifurcation table given as per the cap applicable to the company as per section 197.
Yeah, Kadaja, I think this is a great job. This gives a snapshot of all the remuneration limits for various scenarios, right? It's very well done, very well articulated.
Thank you, sir. Thank you. So moving to the
The
next slide.
only thing is that these
Yeah.
limits can be crossed
Yes, sir.
with the special resolution by the shareholders. Earlier, you cannot cross these these limits unless until you have the central government approval. Whereas now it can be. That means what? Suppose if I am having only one managing director, I have sufficient profits. I want to pay him 7% of the profits as his remuneration. Can I do that? Answer is yes. With the special resolution of the shareholders, I can do that. Similarly, suppose I have two managing directors. To one person, I want to pay 6%. To another person, I want to pay 4%. Can I do that? Again, answer is yes with the special resolution. Similarly, I want to cross that 11%. Can I do that? Again, answer is yes. So all these percentages, whatever we are discussing, 5%, 10%, 11%, 1%, 3%. Earlier, to cross these threshold limits, we want to go to the central government. Now, under the new act, it is completely liberalized. You can pay whatever you want to pay, provided you have sufficient profits. And it is up to the shareholders to approve that or not. So the special resolution is required. However, if you have inadequacy or insufficient profits, then obviously whatever these limits are there, they are to be subject to Schedule 5 sublimits. Yeah.
I think it's a great work from the regulator also. I think they have lived up to the new age of doing things, right? So I think they understood that there is a lot of requests which are coming on this area, and it is the shareholders who are controlling the firm, and they are in the best interest to decide on how much remuneration has to be paid to a director or a managerial personnel rather than they sitting and judging. I think the cases what you were mentioning about 3,500, which was reduced to 2,800, I think they were not getting enough data. There is no scientific methodology to arrive whether 2,800 is correct or 2,000 is correct.
3,500 is correct.
All arbitrary, bureaucratic those days.
Yeah, it's all arbitrary and bureaucratic. I think it's a great move from them because ultimately it is having an impact on the shareholders' interest, right? So there is an impact on the entire balance sheet and the profit and loss account, and therefore it is a wise decision to leave this decision to the shareholders itself. So that's why
In
you
fact,
see a
money,
lot of
it was just like your controller of capital issues in the good olden days. He used to decide the premium.
yeah.
Though there was a scientific methodology was there, they were so conservative. They were not allowing the companies to come with that actual realization of the value of the company's share. Okay, Then, of course, that completely it is liberalized now that the company can decide the premium as far as the share price is concerned. It is up to the shareholders, the investors to decide whether they want to buy the company share or not. At the same point of time, when the Companies Act 2013 has given the power to the shareholders, there were certain apprehensions with the people that whether the shareholders can really play the game, I mean, their role. The way the shareholders are rejecting the managerial remuneration approvals, it means the shareholders have understood that yes, they have the power and they can reject the managerial remuneration approval of the promoters where they are the executive directors.
Yeah, I think no, very good point, great point. I think the one more important development which has happened is the importance of proxy advisory firms, the shareholder activism itself. So therefore, there is a right checks and balances in place. So if there is, I mean, some of the case laws which was put earlier, which you see of the promoter, how they are actually asking for a larger pie in the remuneration, was actually turned down, and for the very well reasons. So therefore, the importance of proxy advisory firms have played a very big role in getting the checks and balances in place. And that's why I was saying in my opening remarks, this is the number one resolution. That is the remuneration to the directors is the number one resolution which has got defeated most number of times. If you see the number of all the resolutions put together, this is the one which is standing out.
Sudhakar, in your olden time, you might have visited n number of times to the Shastri Bhavan. Today, if you have the younger generation, they may not even know where is the Shastri Bhavan is located. That is the way, because everything control was exercised from there. Yeah.
Correct.
Go ahead, Khadija.
So, as we discussed, if the company provides remuneration above the limit of 11% of net profit, so special resolution need to be passed and it needs to be as per Schedule 5. Now, if the remuneration payable to managing director, full-time director or manager, it shall be determined subject to either the articles of the company. If articles are provided by special resolution, then it needs to be passed in the meeting. Now, if there is a term of waiver of remuneration in this section, which speak about they may be paid monthly or based on a percentage of profit. Any excess remuneration need to be refunded within 2 years of or such lesser period allowed, and until such sum is refunded, hold it in trust of the company.
Yeah, please keep.
Yeah. Director receiving commission from a holding or subsidiary company qualified if disclosed. The company must disclose all the director to median employee remuneration ratio in the board report. Now, if the director is contravening any of the provision of this act, then the fine is imposed, that is 1 lakh and 5 lakh rupees. The auditor must confirm that director remuneration complies with this act and any excess must be reported during the year. Now, application pending with the central government under the old provision must be reapproved within 1 year. This was already discussed by Sudhakar, sir. Now, any director who is in receipt of any commission from the company and who is a whole-time director, managing director of the company, shall not be disqualified from receiving any remuneration or commission from any holding company, subsidiary company, subject to its disclosure in the board report. So here basically we have covered the disclosure which needs to be required to be done in the board report. There are two been discussed for the receipt of any excess and if there is any commission being received by the holding or subsidiary company. Then the MD and whole-time director need to disclose in the board report. Now, very important point, and financials also auditor need to disclose about the managerial remuneration. Whether they have paid in the limit or whether they have crossed the limit. So this is very vital point in the case of auditor's term to report in the financial statement. there any light you want to throw on this?
In fact, if I'm not wrong, you're not covered subsection 4, 197, subsection 4, which talks about the directors can be paid for the services provided to the company, provided they are professional services.
I think that is
And
coming later, I
the
think.
That
There
is,
is
NRC
a
yes,
committee or
That is coming later, I think.
yes,
Acha,
sir.
that's
That
coming
will come
later.
in
Okay,
my
okay.
next
Yeah,
slide. Yes.
yeah.
Okay,
She
okay,
is
go ahead.
covering
Sorry.
that. She is covering that.
Because you talked about the penal provision, so I thought you might have
Yeah.
missed out.
No, she
No,
is.
no, sir. That is there in
Yeah.
the next
She
slide.
wants to
Go ahead.
clear audience first.
Okay.
Okay. So, next slide.
But you are going to schedule 5.
So that will come in my sitting fees. That is coming later in my slide.
Acha,
It's
okay.
in Schedule 5 Part 2, actually. I think she's
Yeah.
covered.
She has gone by
Okay.
that. Yeah.
So now let me discuss Schedule 5. Schedule 5 is divided in 4 parts. Now, Part 1 speaks about the appointment related to managing director, whole-time director, and manager. So, the appointee must not have been convicted of any offences under various laws which are described, that is, Indian Stamp Act, Companies Act, in the Income Tax Act, Prevention of Money Laundering Act. There is a list which is given in the Schedule 5 itself. Now, as we discussed earlier also, the appointee must be at least 21-year-old and not older than 70 years. And if he is more than 70 years, then a special resolution needs to be passed and a justification related to it needs to be provided in our explanatory statement. Now, the person must be resident of India. However, this condition does not apply to a special economic zone areas. Non-resident appointed in SPZ must have proper employment visas and must meet the specific requirement, including furnishing detail of their appointment and employing while applying for the visa.
Yeah.
Shall I proceed with next slide? Yeah.
Yeah.
No, go back. That Part 1.
Yeah.
So there are the appointee must not have convicted of any offences under various laws, such as stamp. So there are, of course, they have given a laundry list. There are about 18 laws are there. But there one fine point is that he should not be sentenced for any period. Okay, so any period means even a single day imprisonment is also disqualifying that person for his appointment. As far as fine is concerned, they said that it should not be less than rupees 1,000. That means on 1,000 rupees and above, if it is exceeding rupees 1,000, that fine is there. Even if that fine, that is compoundable offense also, still if he is fined, he will be disqualified. Even if he is going for a compounding also and subsequently. Only thing is there is a difference between a fine and penalty. So if a person has been imposed a penalty on him, he is not getting disqualified under this Part 1. Only it talks about fine, not talks about penalty. Mani and Bala, if you want to anything add further to this.
Yeah. No, I think what you mentioned is correct. I was just trying to see, was there any limitation period for point number 1, which means that
There is no limitation period, Mani. There is no limitation period.
there is no limitation period. So, which means that in his entire history or entire career, he should not be imprisoned.
Yeah, correct. That is what the law stands today. Once
Correct.
disqualified, always disqualified.
Correct.
Yeah.
Which is
See, only thing what it says is he's not disqualified as such, but the only thing is you have to go to central government approval for
correct.
appointment of that person. Shareholder approval is not sufficient. You have to go to central government, number 1. Number 2, once central government gives you that permission, when the same person is getting reappointed, that point of time, you don't have to go back to the central government once again for that. because once it is given means it is for his reappointments also, it is automatically done.
Now, is that the interpretation, Sudhakar?
No, it is clearly there in part 1 itself. It is not interpretation. It is clearly there. It is provided clearly that once the central government gives the approval for his appointment, for the succeeding reappointment, such central government approval is not required. It is clearly mentioned in the schedule itself.
Yeah, in the proviso. Yeah, understood.
Correct.
Yeah, that is right. Yeah.
Got it.
Go ahead. Go ahead. Telugu.
No, so the previous one, the one point which they have mentioned about the people, sorry, please can you go back for the expats who are coming, right? So they have to definitely be a resident. They have to be permanently resident in India. I mean, not permanently, they should have a valid visa and they should be residing for a year is a pre-qualification. However, it is only exempted for the SEZs.
Yeah. In the case of the other than the SGS, they should have been a resident for India for about a year. So
Correct.
for the limited purposes, that will be treated as good as an Indian, and it will be considered. If it is not the case, because they are not fulfilling that condition, then government approval will be called for.
You have to go back to the central government further.
Yeah, if they stayed in India for about a year, then there is no problem. So normally what people do is they bring him as a technical technician or something like that, and that they make him to work for about a year. Then after that, generally people appoint as a managing director. That's what they normally do. Yeah.
Yeah. Now, one more new development is STZ. Now that IFSC has also come out in the gift city. So that's where you'll see a lot of new companies who are coming out with a different, the multinationals are coming and setting up the entities over there. So maybe a lot of applications will come from this.
Yes, go ahead. I think we are already 12:20. Yeah.
Okay.
Yeah.
So here we have discussed part 2. Part 2, section 1, that section part 1 says about remuneration payable by companies having profit. So in case of profit, we need to follow as per section 197 and schedule 5. Now special circumstances in case of excess remuneration, that is allowed in certain conditions. The conditions are given. That is, first, if another company pays the excess remuneration in case of newly incorporated company and SIC companies, and companies under a resolution plan which is approved by the NCLT. Now, perquisite excluded. What are the excluded perquisite from the managerial remuneration? What needs to be excluded? There are provident fund contribution, the gratuity, and leave encashment needs to be excluded. Now, the remuneration payable to a managerial personnel in case of two companies, a manager person can draw that remuneration from two companies, provided that the total does not exceed the limit of either company. That is as we discussed earlier, the 11% limit. Now, additional requirement. Additional requirement, here we will talk about the additional approval. So, the recommendation needs to be done by the NRC committee, and then the board approves it, provided subject to the approval of the shareholder in the meeting. Now, here we have mentioned that corporate governance report, disclosure needs to be given about the remuneration in the corporate governance report. And earlier also discussed by Sudhakar about 197.12, that a median remuneration, that I will discuss in my next slide, where I will cover the board reports disclosure. The employee median remuneration needs to be disclosed in the board report. Panelists.
Go ahead. They will
Go ahead.
speak.
Go ahead.
Okay. Now,
You go ahead. They will speak when they want to.
Okay. Now, remuneration, this I have bifurcated in the table format. The remuneration for companies with no profit or inadequate profit. So there are effective capital which is being mentioned, and according to that, the limit of yearly remuneration which should not exceed in case of a managerial personnel and in case of other director, that is mentioned. So if my paid up capital is negative or less than 5 crore, then in case of limit of yearly remuneration payable shall not exceed 60 lakh in case of a managerial personnel, and should not exceed 12 lakh in case of other directors. And if my capital is above 5 crore but less than 100 crore, then in that case it is 84 lakh yearly remuneration in case of managerial personnel and 17 lakh in case of other directors. And if my paid up capital is above 100 but less than 250 crore, then it is 120 lakh in case of managerial personnel and 24 lakh in case of other director. Now, if it exceeds the 250 crore and above, then 120 lakh plus 0.01 of the effective capital in excess of 250 crore, whatever it is, and 24 lakh plus 0.01 of effective capital in excess of 250 crore. So we need to add if there is addition in 250 crore, the percentage. Now moving to next slide. It talks about
1 minute. Just go to the earlier slide. Various CS has doubt about or understanding about inadequate profit. When is the profit is inadequate to pay remuneration? As can you elaborate in the condition when there is a fixed remuneration to the director plus percentage of profit, and when there is only remuneration percentage of profit. No profit is clear, the situation. But when a person has to refer to this table, when the profit can be said inadequate profit. This is many times fresh CS or get has confusion. So can you elaborate on that?
I think if you go to the 198 explanation, there is a definition of how you need to calculate the effective capital. Right? Why don't you go to that? Then you will understand what are those limits. So when you come out with those 1%, 5%, 10%, 11% limits, so if the effective capital, once you take the effective capital and you apply that percentages, if the amounts are exceeding, then therefore it is an inadequacy of profit. Therefore, you need to go back and take the shareholders approach. So that's the broad principle. But I think you can see the definition of what is an effective capital under, I think it's, are you covering in the next slide?
Yeah.
yes,
Okay.
sir.
Okay. Did I answer your question, ma'am?
Yeah, but at that time, practically again I explained because many CS ask these questions. That's why I am asking.
Okay.
And it comes effective. Yeah.
So part 3 covers remuneration payable by companies having no profit or inadequate profit in certain special circumstances. So the appointment and remuneration is outlined as part 1 and must be approved by a resolution in the general meeting. And if a company auditor or company secretary or a whole-time company secretary must certify compliance with requirement of this schedule, the certificate must be filed included in the written file with the registrar. So in case where the company doesn't have a company secretary, then a certificate from a whole-time CS needs to be filed in that case. But if there is a CS, then he needs to provide or she needs to provide that certificate. Now, part 4, the central government has the authority to exempt specific classes or categories of company from any requirement of this schedule through a notification. Now, calculation of profit as per section 198. Here we have covered what all things needs to be included in section 198 while the calculation is being done for net profit and what needs to be deducted. So credit and non-credit item, credit should be given for bounties and subsidies received from government or public authorities unless directed otherwise by the central government. Credit should not be given for. So there are 5 points which are being mentioned. That is sale of forfeited share, then share or debenture premium, sale of immovable property or capital asset, and unrealized or notional gain including revaluation of assets. Now, what all deductions is allowed in section 198? That is the following items: usual working charges, depreciation, then business profit tax, repair expenses, insurance premium, compensation or damages against the legal liability. All these deductions are being allowed in while calculating section 198. Now, items which not to be deducted. So the item which should not be deducted while computing net profit is capital losses, including those from sale, any changes carrying out in the asset or liability, any voluntary payments such as compensation or damages, super tax, income tax, or other taxes on company income, which are except those on excess or abnormal profit. Now, very important, sitting fees. So a company may pay a sitting fees. So a director may receive remuneration for attending board meeting, committee meeting, or as may be directed or decided by the board of director. Uh, however, they should not exceed 1 lakh rupees per meeting of the board or committee, provided there is a proviso over here that whatever amount we are paying to other directors should not be more than the payment which is done to independent director and woman director.
In fact, several people ask a question that in case of sitting fee paid to the independent directors for the independent directors meeting. So some people ask the question from where the power is there, the board or shareholders to decide that. Because it is neither a board nor a committee independent directors meeting. But actually, subsection 5 clearly says that sitting fee can be paid for any other purpose also, that board has been given that particular power. So under that, certainly independent directors meeting, it is a prerogative of the company. If they want to pay, they can very well pay that thing. And it is advisable to obtain the approval of the shareholders also. Mani, you may express your view also on that.
No, I think what you mentioned is absolutely correct. I think I'm just trying to bank on this. Our committees thereof, such some as may be decided by the board of directors thereof. So which means that there is enough powers for the board to decide if it can pay for the independent directors meeting itself. And I think it goes back to the principle of if somebody has spent their time, then they are entitled to be remunerated, right? So that is going back to that principle. And only then you can draw the good talent, or you can ask them to contribute for the well-being of your company, right? Otherwise, it is a disproportionate thing, and then you may not get best out of them. So from a principle of equity also, it is correct in my view.
In fact, many companies are actually paying the commission because it is as good as like any other committee meeting. That is the interpretation. But of course, as you rightly say, some of the companies, they don't. But many companies, they do recognize this is as good as another committee meeting, and they do pay.
Yeah.
And
whole
similarly,
I know many
if you see the
companies.
wording of the section. Yeah, Mani, go ahead.
Sorry, no, I was just saying that in fact many companies have a practice of convening the board meeting on the date of AGM, because the wording doesn't allow to make a payment to the general meeting. If the directors are participating, what they do is they do either before the AGM one board meeting or after the AGM another one.
Yeah, that is most of the company they do morning. If you see, there's a board meeting in the morning, and in the afternoon there's a annual general meeting. Yeah, that is true.
See, Mani, can I say that one senior company secretary, I don't want to give name for obvious reasons, he was telling me under this subsection 5, even the board can decide to pay the sitting fees to the directors for attending the AGM also. So legally it may be tenable, but as a good governance, it is not so, because it is not only the directors who are spending that time, it is the shareholders who are also spending that time for attending the AGM, which is not correct. Paying the sitting fees for AGM is not at all correct.
Yeah.
Correct,
And
absolutely.
similarly, and even paying the sitting fees to the independent directors, though as per the wordings of the section, it is within the powers of the board, but it is advisable to obtain the approval of the shareholders also, for that. One time only, not every time. One time it is approved, and then they get the power delegated to the board to decide as far as the enhancements or increase the sitting fee is concerned. But that is as a good governance measure. But as far as the law is concerned, it is within the powers of the board.
The only point, Sudhakar, is the limit is 1 lakh rupees per meeting.
Correct.
So
Yeah,
that
yeah.
you enhance. I mean, for whatever reason, this 1 lakh is not increased for a very, very long period.
Yeah, that is true. That is true. Yeah.
Correct. 10 years. 10
Yes.
years.
Yeah.
Go ahead,
Yeah.
Khadija.
Okay. So disclosure, what all disclosure needs to be done in the board report is
Do one
disclosure.
that 197.4 you crossed or not yet? I'm not able to make it because I have a point in 197.4. That's why I'm very particular about it. Have you crossed it or is that to come?
No, it will come, sir.
Yet to come, yet to
It
come.
will come. Okay.
Yeah.
Yeah.
Okay. Okay.
Coming soon.
Patience, Sudhakar.
Okay.
Yeah.
Okay, sir.
Okay.
I just
Okay.
want to, so this is a very important slide, especially for the listed companies.
Ah,
This is a very, very important slide. And there were a lot of representations and there was a lot of push why these disclosures have come. Of course, these are in excessive. Some people are actually arguing to say that this is very excessive. I mean, I also agree that to a certain extent there is an excessiveness and there is a proprietary information. In fact, this is one area where actually you get confronted with various stakeholders, right from your HR to the management, everybody, of why should we give this kind of information? Because in their point of view, there are only two kind of people who can come after this. One is uh, the peer companies can be looking for this data for poaching purposes, or some disgruntled employees saying that I have not received a higher salary when compared to my peer. But having said so, for whatever reason, the regulator has thought that this has to be provided because they thought that this is a shareholders' money of how it has been getting paid to the managerial person, and to be transparent whether there is any disproportionate payment of money to any of the relatives or any siphoning of money. So that's why they wanted this provision to stay. Having said all of that, I think this will change because there is a data privacy bill which is in the works right now. So once it comes out, many of these are personally identifiable information, right from the name is not, but the age, the remuneration, there are so many personal details. So mostly these things will get tweaked. I think this is one area which we can look forward for some amendments in the near future.
Okay. So disclosure in the board report. First is that every listed company shall disclose in board report ratio of remuneration of each director to the median employee's remuneration. Then further, we need to disclose about the employees, the detail of employee designation, their remuneration, their nature, their qualification as discussed by Manikantan sir. That various personal details are also need to be disclosed. Experience, their employment start date, end date, their age. This all needs to be disclosed in the board report. Then the board report will firm that remuneration aligns with the company policy. That also needs to be disclosed in board report. The report, then the top 10 employees in terms of remuneration and the earning more than 1.02 crore annually or 8.5 lakh monthly, along with employee earning more than managing director or whole-time director and holding of at least 2% of company's share. This also needs to be disclosed in the board report. Then the number of permanent employees and average percentile salary or increase for managerial staff compared to managerial staff must be disclosed along with their justification for exceptional increase in managerial remuneration. So these are certain points which we need to disclose in the board report.
So there is the one point which I just wanted to highlight. There is nothing which
Yeah.
we can do about it, but the limits which you see for the people, for the employees who are in India, the limit is 1.02 crore. Whereas the salary which is paid for the employees who are outside India, it is 60 lakhs. It's actually a very low amount when you have a higher limit of 1.02 crores in India and 60 lakhs outside. It somehow it is logical. It is not chilling well.
Right. It should be more rather.
It is. It should be more, but for whatever.
Reverse actually. Yeah. Mm.
Yes, go ahead.
Now the parameters which needs to be covered while consideration for remuneration. So first is the principle of the relation between the remuneration and the performance. The securities held by the director, including the option and detail of the share pledge at the end of the preceding financial year. The remuneration policy for directors differs from remuneration policy for other employees, if so.
So I think
The financial.
sorry, I just want to make one point in this. I think the biggest takeaway is that every company should have a nomination remuneration policy. And that nomination remuneration policy should actually describe about what are your pay philosophy for your directors, for your KMP, for your senior management, and for the rest of the organization. And that has to be reviewed by the nomination remuneration committee and the board on a periodic basis. I think that's the takeaway from this slide.
Okay. Now, section 199, which talks about recovery of remuneration in certain cases. So it applies to past and present managing director, whole-time director, manager, or chief executive officer who were in office during the period affected by the restatement. The provision mandates the company is required to restate in financial statement due to fraud or non-compliance. The company must recover in that case the excess remuneration paid to certain key officers. Now, this ensures the accountability and allows the company to reclaim inflated compensation tied to inaccurate financial statement.
Yeah, no, I think this is one more important point where most of the company would have not noticed this provision. So this is a clawback provision, which means that if somebody has been remunerated for inflating or if the further misstatement of numbers, if that gets restated, then the excess payment which has been made has to be pulled back from the executives whom it has been paid. So I think one of the important point will be to include this is as part of your agreements with the executives itself, so that tomorrow you don't get into a contractual litigation and it can protect you.
Okay. So forms and procedure in relation to certain applications. So every application made to the central government under section 196 and such form as may be prescribed, that is the form is MR2 in this case, which needs to be filed within a period of 90 days from the date of such appointment. Before any application is made by a company to the central government under section 196, there shall be issued by or on behalf of a company a general notice in that case. Now, the copy of the notice together with the certificate as to due publication thereof should be attached to the application made to the central government. Then a notice, that is a public notice, needs to be given in the newspaper, that is of the where the registered office of the company is situated. That is at least once in an English newspaper circulating in the district. Now the very important topic 202, compensation for loss of office of managing or whole-time director or manager. A company may compensate a managing or whole-time director or manager for loss of office, retirement or related reason, but not any other director. No compensation is allowed if there are certain cases in which compensation is not allowed if the director resigned due to company reconstruction or amalgamation, and if appointed to a similar position in the new entity, if the director office is vacated as per section 167(1), if the director is guilty of any fraud or he have done any breach of trust or negligence or mismanagement in the company, then the director resigned without such restructuring. In all that cases, no compensation is allowed. Now, compensation must not exceed the remuneration the director would have earned for the remainder of his term of 3 years, which is charted based on their average remuneration over the past 3 years. No compensation if the company is wound up within 12 months of the director departure and the assets are insufficient to repay shareholder. Now, this section does not prohibit paying the director for other services rendered by the company. Shall I proceed with 203?
Yeah, go ahead.
What
Okay.
Sudhakar was asking, it's still not come that on the on the payment which can be done, which can be made for in a professional capacity.
Professional services.
Yeah, that is that any remuneration.
What I was, it doesn't matter. 197 subsection 4, what it talks about is that directors can be paid for their, any remuneration for the professional services, which is not part of a managerial remuneration. This means that even a managing director can also render professional services, provided his profession is recognized by the board or by the NRC committee. And if that board, NRC is not there, then by the board itself. Otherwise, both NRC as well as by the board. It will not be a part of managerial remuneration. Several times the question comes whether managerial remuneration, the managing director is a related party. So whether approval under section 188 is required or not required. When you are appointing the managing director for the first time, before his appointment, he is not a related party. Only after his appointment, he is becoming a related party. So obviously, there is no question of related party transaction. The question comes as and when he is getting any kind of increase in his salary or his reappointment comes at point of time, only the question of related party transaction comes into picture. Even at that time also, it is going to be in the ordinary course of business and at arm's length. So that exemption can be availed. That is one rationale. No related party transaction approval under section 188 is required. The second rationale is that wherever there is a specific section is there, and you are anyway obtaining the shareholders approval under that subsection, under that specific section, then section 188 approval is not required. So anyway, you are going to take the approval under 197. So obviously that shareholders approval by way of a resolution or special resolution, whatever the case may be. So section 188 approval for related party transaction is not required. Another thing is, suppose, for example, if the managing director is rendering professional services and his service contract provides for that, and the board approves whether it is a related party transaction and whether shareholders approval is required. This particular scenario we have very well comprehensively discussed in the related party transaction, RPT guidance note. For the benefit of participants, let me say that if the managerial person is rendering any professional services which he is permitted as per the service contract, and the board approves that, NRC committee approves that. So no, because it is going to be again in the ordinary course of business and at arm's length, if that exemption is availed, then 188 approval is not required. However, please ensure that 197 subsection 4 approval is taken. Several times it happened that, in fact, I have two people have asked me this question because they had made a non-compliance. What they did was they have taken it as if it is in the ordinary course of business and arm's length, and they have taken care of 188, so no approval is required. So they have not obtained the shareholders' approval, but they got stuck because they have not taken the 197 subsection 4 approval. This is a very, very important thing. So whether RPT is applicable or not applicable, you have to be very careful about this. This is, I thought, I will bring to the notice of the participants. Yeah.
Okay. So section 203, that is appointment
Okay,
of key managerial person.
just to add one more point, at the time of reappointment, if you're considering that as a related party transaction, right, the remuneration, then the problem is all the related parties cannot vote on that resolution. So you need to look at from that perspective also. Therefore, it is more logical to consider that under section 197 and take an approval as a reappointment, rather than going under 188 or on the any other provisions of related party transactions.
It is not required also, in fact.
It is not required. Yeah. It is not required.
Yeah. Because this particular question, 15 number of times I have been asked whether for managerial remuneration 188 is applicable or not. My request to the participants is please go through the guidance note on RPT. It is very clear, very well elaborately explained this particular aspect, and no approval under section 188 is required either in the first time or at the time of renewal also.
No, first time definitely it is not applicable because he is not a related party as of now. The second time is where you may want to take a guidance. But having said that, the other part which which everybody has to take care is about the disclosures. There is no exemption under the disclosure. So it is considered as an RPT. Therefore, you have to make the disclosures, at least in the existing regime of Reg 23.
Yeah.
Okay. So section 203, appointment of KMP. Same person cannot be appointed as chairperson and managing director or CEO unless the article provides for the same. And if the company is engaged in some multiple business and with different CEO, for each may be exempt for this. Now, key managerial person must be appointed by a board resolution specifying the terms and including the remuneration. If a KMP position is vacant, the board must fill within 6 months. A whole-time KMP cannot hold office in more than one company except in subsidiary unless permitted by the board. And KMP already having holding office in more than one company, he may choose within 6 months of the act any one company from that. Now the penalty provision for this is company that failed to comply with this provision face a penalty of 5 lakh, and each director and defaulting KMP will be fined rupees 50,000 with an additional of rupees 1,000 per day for continuing default up to a maximum of 5 lakh. Now section 200.
Just one point on the previous thing. The time limits are different under the listing regulation. It's 3 months. So that participants may want to take note of it. The filling up of the vacancy, let's say.
Now section 200, central government or company to fix limit with regard to remuneration. So central government, while approving under section 196 to any appointment or any remuneration under section 197, where the company has inadequate or no profit, can fix the remuneration within the specified limit or such percentage of profit of the company as it may deem fit, and while fixing the remuneration shall have regard to the following points, that is the financial position of the company. What is the financial position? The professional qualification and experience of the individual, the remuneration or commission drawn by the individual in any other capacity if he is appointed, the remuneration or commission drawn by him from any other company. Now, so here we have covered SEBI regulation, which talks about the managerial remuneration and about the KMPs and everything. So we have covered only few regulation over here as we are here to discuss about the Companies Act more. So we have only one slide on this. So Regulation 34(3) and Schedule 5, Part C, talks about company must disclose a pecuniary relationship or transaction of NED with the company. Now, Regulation 34(3) itself talks about disclose all the element of remuneration for individual director categorized in major groups like salary, bonus, stock option. Now, in case of stock option detail, including issuance at discount or the accrual or exercisable period should be disclosed. Now, 34(3) itself talks about information on services contract if notice period or any service is related to director needs to be disclosed. Regulation 19(4) under Schedule 2 of Part D, Para A, terms of reference, composition, meeting, attendance of NRC needs to be disclosed by the NRC. Then 46(2), details about the criteria for payment to NED must either be provided in the annual report or posted on the company website with reference included in the report. So, sir, do you want me to take on that case law of Saluja and that we
Yeah,
discuss?
now you can take up. Yeah.
Yeah.
I was about to say that.
Okay. So, in this case law, Siddharth Lal was appointed for reappointment as managing director. In 2021, the proposal included a 10% salary hike during that pandemic, despite decreased company revenue, and institutional shareholder rejected about the reappointment and the salary hike, which was recommended, with significant opposition at the annual general meeting. Now, in this case, particularly, it held that the shareholder, particularly institutional investor, opposed the salary during a period of financial downturn. The board later revised the compensation proposal and eventually gained shareholder approval after adjustment.
I think this is one of the important case where actually the promoter Siddharth Lal was a promoter actually of the company, and his remuneration was proposed um, by the company, and which was taken very seriously by the shareholders. And, they did not allow this thing to happen where there's a reappointment and there's also a salary hike. So the resolution got defeated, and then it pushed the company to come out with a different set of terms, which is much lesser than the first time what it was proposed, and they proposed the second time with a lower limit. And after that, it went through. I think there was a lot of negative media which was covered on this. Added to that, the proxy advisory firms also had a strong opinion that this should not be allowed, given that the promoter himself is asking for a revision of payment, which is not good from the corporate governance point of view. Yeah, you want to
Move forward.
Okay. So this is about Dr. Saluja case. The recent Dr. Saluja case involves significant issue related to managerial remuneration and appointment, particularly concerning the violation of regulation by Railgate Enterprise Limited and a subsidiary Care Health Insurance Limited. So in this case, majorly Dr. Rashmi Saluja, the non-executive chairperson and executive chairperson, was granted a large number of employee stock option valued at over 480 crore. However, the Insurance Regulatory and Development Authority rejected that due to the conflict of remuneration guidelines for non-NEDs. Under the Insurance Regulatory Development Authority guidelines, non-executive director are limited to receiving profit-related commission and sitting fee, but not ESOPs. So, despite IRDAI rejection, they proceeded with granting of ESOP to Dr. Saluja, which led to the regulatory investigation. And further, the ESOP were issued to her in her capacity as an executive director in RRL and non-executive chairperson in CHIL. However, IRDA maintained that the grant violated its guideline, triggering further regulatory scrutiny. The case highlight of the complexities of the managerial remuneration, especially when individuals hold position across multiple entities, and underscore the importance of adhering to regulatory guidelines in corporate governance.
Yeah.
So next is proxy advisory firms.
I think everyone knows this weekend.
Yeah, this is fine.
Yeah, go ahead.
Yeah, move forward.
Ma'am, then that's it. We have covered everything in our slide.
I think we are closer to 1 o'clock. I think we'll just run through the questions.
Yeah,
Khadija, you have done an excellent job. Nice presentation.
Thank
You have
you so
covered
much,
almost
sir.
all the points. Our appreciation to you.
Thank you,
Thank you so
Kadija.
much,
Very well
sir.
done.
Thank you.
Very well
Thank you,
done. Thank
everyone.
you.
Yeah, really a good job.
Yeah, matter has come up in the public sector private company where clarification was sought. The company secretary and finance executive has been called CFO, although there was no legal compliances to do the just because the previous incumbent was influential with the government. He started using it. The next man was recruited, appointed the same basis without giving much thought. Now is it necessary to disclose emolument paid to the CFO as is statistic listed companies?
This is not for MD or CEO. This is for different. We can skip this and go to next question.
Okay. What should be the date of the appointment of the independent director when the board appoints him, or the additional director, or when the chair? Yeah.
It is board meeting date, form filing required to form filing, effective board meeting date for appointment of director and managing director. Two,
Okay,
three
next.
questions are relevant to that, answered everywhere.
Okay, next one is actually appreciation to Sudhagar. Then form MR1 to be filed in case of the managing appointment within 60 days appointment of the appointment date when the board resolution or when the shareholders approval of the appointment. I think this also you discuss, I think.
Discuss, yeah, 2, 3 questions are left.
Okay, kindly cover the appointment of the managing director and subsidiary and deemed public company. Can one appoint the managing director as a director not labeled by rotation? I think this also we discussed actually elaborately. There was a discussion on that. Why so from the shareholders resolution because the appointment starts from the board. This also we talked about it. Okay. Mani sir, you said that the independent director required to be appointed by the shareholders in the listed company and not by the board. Can you please clarify with the relevant regulations because most of the companies are appointing independent directors at the board meeting.
Yeah, no, I said that it has to be the board will appoint. The shareholders will have to approve within 3 months.
Yeah, that is right. In 5 years counted from this, we have talked about it. Can you please highlight the filing of the form of DR 12 when a person is appointed as a director and MD in the same board meeting? How many DR 12?
Answered.
Answered, okay. Then there is a precedent set by the courts that the KMP's appointment in the private companies are also governed under section 203. Will there be a limits applicable to the private companies?
Limits of what?
There is a precedent set by the code KMP appointment in the private companies. Is it 203? I think 203, where is the limit? 203 is only the appointment. And
only for public companies.
Yeah, and the private companies are out of the limits of the managerial remuneration. In case of the private limited company, director are entitled to 10% of the profits to be shared by the MD, JMD, WTD equally. In addition, every year they get about 1 lakh rupees of the salary and perks of car reimbursement, telephone expenses, medical expenses, etc. for dependent children.
Bala, for private companies, the percentages are not applicable.
Okay.
197 subsection 1 is not applicable to private companies.
Correct. It is only the appointment is applicable, not the remuneration related provisions. Can an Indian having a dual citizenship, that is America and India, can be appointed as a MD, a director in the company, if he is staying 6 months in India and 6 months in US?
You cannot have a dual citizenship. You cannot have the citizenship of both US and India.
India doesn't allow. The other countries will allow, but India doesn't allow.
And there's a precedent set by the court. Yeah, this we talked about it. Whether the remuneration to the non-executive director can be paid based on their attendance in the board meeting, committee meeting, or named remuneration based on their performance and not as a sitting fees. No, sitting fees is different, and they get only the commission and the sitting fees. And commission,
Yeah, commission can be paid. Yeah. See,
Yeah.
you don't need to pay the commission uniformly to all the directors. You can discriminate depending upon their performance. Also, you can pay the commission.
Yeah, according to the board, whatever the methodology they decide is left to the board.
Correct.
Yeah, it can be either attendance or it can be performance. It can be different from different things. Yeah. Out of the top 100 companies, 25 companies are disclosing the top 10 employees list, which means the rule 5.2, why they are not complying with the same. I cannot answer this question. If they are not complying it, if they are doing a non-compliance, I think regulator will take action.
I mean, everybody is complying is what I can see, because we have seen many companies are complying with it.
No, listed companies, I see this all happening, but some of the unlisted companies, especially ITPs where the foreign people are working, some of the, I think I've seen few cases which are not there, probably maybe referring that. Yeah. List of some employees covering more than 1.0 crores is disclosed. Is it class applicable to the unlisted public company?
Yes, it is applicable.
Yes, it is applicable. Is MGT 14 applicable to appointment of the MD in a private company?
No.
Article,
MGT 14.
Yeah, under this 117.3C.
Article 9 restrict the double six. Yeah, that's all. I think so. That is all I think so. Yeah.
No, I don't know if anybody else has any questions.
Anybody else has got queries, they can raise their hands. We can take. I think, Khadija, you can close the presentation.
Yeah. I think it's not there. People are in Ganpati mode.
Yeah, that is what it appears to be, because they are in the festival celebration mood.
Yeah.
Yeah.
Okay.
I think we can close the session, I think, since nobody has raised the thing.
Before you close, I just want to place my sincere appreciation to Khadija for doing a wonderful job, and to entire firm of Mehta and Mehta. It's a wonderful to be here, to be a part of this panel. And I personally got an opportunity to read this. You know, we read only this when we encounter some issue, or only once in 5 years when you have a requirement of appointing a managing director. So this actually helped me to read a few things, and thanks for educating me. Thanks a lot.
Thank you, Mr. Manikantha. Thanks a lot. Thanks, Sudhakar. Thanks, Bala. Thanks.
Thanks a lot to everybody. Enjoy the Ganpati festival. We yet meet in another session.
Yeah.
Yeah. Thank you. Thanks a lot.
Thanks, Mani.
Thank you.
Thank you, everyone. Yeah. Bye.